Hello, I'm Bruce Chasan, a registered patent attorney and litigation counsel in Philadelphia. Phone number 215-567-4400. Today I'm going to discuss what to do if your company receives a cease and desist letter from a patent owner's attorney. Let's assume you are ABC Company and you sell widgets. A letter comes from an attorney for XYZ Company stating your widgets infringe XYZ's patent. The letter identifies the patent number and it states you could be liable for money damages, royalties, and attorney's fees, and it also states you could be subject to a preliminary and permanent injunction. What do you do? First, you should quickly contact a patent attorney such as myself. Your patent attorney can explain the risks and defenses. As to the risks, in a worst-case scenario, the patent owner, XYZ Company, wants a preliminary and permanent injunction to stop you from selling widgets, and it also wants money damages in the form of lost profits due to your competitive sale of widgets. If XYZ can prove you were willfully infringing its patent, it may be able to recover enhanced damages up to 3 times its provable damages and also attorney's fees. If you are enjoined and have to pay damages, you could be in a world of hurt. But alternatively, the cease and desist letter may be a negotiating ploy to get you to enter into a license whereby you would pay a royalty on each and every widget you sell. Your patent attorney should immediately analyze your widgets to see if they are covered by the claims of XYZ Company's patent. There are 2 types of infringement. The first type, namely literal infringement, is when the features of your widgets are found in each and every limitation of the patent claims in XYZ's patent. Alternatively, there is infringement by the doctrine of equivalence. In that case, there may be a feature of your widgets which is not identical to one of the limitations in the patent claims, but it is close, and the feature serves the same function in the same way to attain the same result. Thus, your widgets can still infringe XYZ Company's patent, even if there is a slight difference in one of the features of your widgets compared to the XYZ patent claims. Patent infringement cases usually involve at least 2 types of expert witnesses. There are experts with regard to the particular technology, and they provide expert opinions on whether or not the accused device infringes the patent and whether the patent is valid or invalid. Another type of expert is an economist or forensic accountant. These experts opine on damages issues such as lost profits and reasonable royalty. Your patent attorney should immediately begin to study the prosecution history of the patent. Well, what is that? A patent in the United States has passed an examination process. A trained patent examiner has examined the application and made a determination that it meets all the statutory criteria for patentability. That is, the application passes muster and a patent is issued. There is a written record in the Patent Office which is called the Prosecution History File. It is common for patent examiners initially to reject patent claims and applications based on printed publications and prior patents, which are called prior art. Very often, the patent applicant will amend and narrow the claims it is seeking in light of rejections by the examiner that cite prior art. This written record is helpful in understanding how the applicant may have narrowed the patent claims to get the patent allowed, so that possibly they do not even cover your widgets. The patent attorney reviewing the prosecution history will also look at the prior art in the file cited by both the applicant and the examiner and do a literature search to see if there is additional prior art that would have rendered the application unpatentable if only the examiner had known about it. So, in addition to non-infringement, your patent attorney should investigate to see if the patent is invalid as not being novel, or because of obviousness, or because of other grounds in the patent statute. But the burden of showing that a patent is invalid is high. You, as the seller of the accused widgets, have to demonstrate patent invalidity by clear and convincing evidence. The patent owner, however, only needs to show infringement by a preponderance of the evidence, which is a much less burdensome level of proof. Your patent attorney has to act quickly. It may be that XYZ Company is ready to file a patent infringement suit and seek a preliminary injunction that could stop your widget sales cold. To defeat a preliminary injunction, your patent attorney needs to show it is more likely than not that your widgets do not infringe the patent or that the validity of the patent is vulnerable. The standard of proof at the preliminary injunction stage is less rigorous for the accused infringer than it is at the time of the final trial on the merits. But you have to be ready. You can't be caught flat-footed. Your patent attorney can explain your options. One route is to try to persuade the attorney for XYZ company that the infringement case is weak and should not be brought in the first place, or that the patent is vulnerable. One outcome of this is that the patent owner backs off, and another is that the case gets settled for a very modest royalty. But if there is a colorable argument that your widgets infringe, you might be able to design around the patent and sell a modified widget profitably. You have other options before you get sued. You can file a declaratory judgment action in federal court in a venue of your own selection, seeking a declaratory judgment of non-infringement and/or patent invalidity. You will still have to prove patent invalidity by clear and convincing evidence. The patent owner may file a counterclaim for alleged infringement, seeking damages and an injunction. There are certain remedies available in the Patent Office. You may be able to file one of three types of proceedings. First is an ex parte re-examination, whereby you bring patents and printed publications to the attention of the Patent Office, with the objective that the Patent Office will cancel the patent or amend the claims so as not to cover your widgets. Second is an inter partes review, where you actually have a litigation in the Patent Office over the validity of the patent based on the prior art, and you also have a right of appeal to the Federal Circuit Court of Appeals. Third is a proceeding called post-grant review, where you can challenge the patentability of recent patents on multiple grounds, not just invalidity based on prior art, also with a right of appeal to the Federal Circuit Court of Appeals. The filing fees in the Patent Office are very high, running into thousands of dollars, but the burden of proof is lower for the challenger than it is in federal court. In the Patent Office, the examiners and the Patent Trial and Appeal Board apply a preponderance of the evidence standard. If you have been advertising your widgets for sale, your attorney may also review your insurance policies to determine if your insurance carrier must provide you a defense or otherwise pay for your defense. This is a very brief summary of what needs to be done to respond to a cease and desist letter. If you find yourself with any aspect of such a problem anywhere in the country, call me, Bruce Chasan, at 215-567-4400. Thanks for joining me today.